Welcome everyone to another Technology and Access to Justice talk as part of our series talk here at UNB Law. We recognize and respectfully acknowledge that the Faculty of Law at the University of New Brunswick community gathers on the unsurrendered and unceded traditional lands of Wolastoqiyik. And we also welcome you on behalf of the Legal Innovation Lab team. Please join us join me in a warm welcome to Professor Heather Heving, Associate Dean Academic at the College of Law of the University of Saskatchewan. Welcome, Heather, and thank you very much for joining us today. Professor Heving has helped establish the Create Justice Research Center at the College of Law. And in addition to her very impactful work on access to justice, she's been her research is also focused on international and domestic trade and business law, and more recently, areas of risk assessment. She's also the Dean of Research and Graduate Studies at her university. Now, Professor Heaven will discuss information needs to support evidence-based decision making and to measure improvements in the justice sector in justice, and share with us the developments and commitments towards making these improvements, and perhaps also towards a data common in the province of Saskatchewan. The floor is yours. Thank you again very much, Heather, for joining us and sharing your work with us.
Thank you so much, Dr. Penzeni. I was thrilled to attend the Canadian Association of Law Teachers Conference in New Brunswick this past summer, and had the wonderful opportunity to meet you and to learn about some of the work that you're doing in New Brunswick. And so I know that as we move forward, I'm going to be continuing to call upon you as well, and you're going to become part of my network, so to say, because there's a few of us that are quite passionate about the topic of justice data and how we can improve decision making that is data informed. But we recognize that there is some challenges to that, and that's really what I'm going to talk to you about today. So. By way of an overview, I want to just let you know what I want to talk about in the next hour or so that we have together, or I guess it's an hour that we have together. I want to spend a little bit of time explaining the interest of our Saskatchewan justice sector organizations in trying to enhance our capacity to use data for continuous improvement. Much of my focus has been in the civil and family justice areas, and that's partly because of the Access to Justice Network in Saskatchewan that we have created that has been focused primarily on civil and family justice, although we recognize that in the criminal justice has needs as well. But we recognize that in civil and family justice areas that some of those needs are even more prevalent because they've maybe been under-resourced or maybe not looked at in quite the same depth as criminal justice or corrections and policing. The second thing I want to do is share some information about Saskatchewan's legal data scan report. I guess I was the project lead on a study that we undertook as part, it was part of a two-part study that we did. We did a legal needs assessment for the province, and we also at the same time did a legal data scan. And so today I'll be talking about our legal data scan. I believe a copy of that or a link to that was also provided to anyone that might have read it prior to this talk. The third thing I want to talk about is some identified priority areas that we in Saskatchewan, our Access to Justice Network, support in trying to advance data-informed decision-making within our justice sector. So as I move into this, I want you to think about a couple of questions. We recognize that there are many legal and non-legal organizations that are involved in our justice sector. Many of us are involved with them either, in in various capacities. We take various roles within these agencies or within these organizations, and we collect data. And the question are always around, well, what data are we collecting? How could we use data more effectively to help inform not just our work, but inform access to justice initiatives in general within the sector? We recognize, and I don't think New Brunswick is any different, in Saskatchewan, we do not have a provincial data commons or an easy way that we can readily access or share data that is being collected by, I'll say, justice, legal, or non-legal organizations. And that can be a hindrance in our ability to really understand what's happening in the sector, and it's a hindrance to make better informed decisions based on that information. So I ask, three questions. How does your own, and just jot these down for yourself if you'd like, or I even suggested we could share them in the chat, but I'm not sure if that chat function is happening during this. But if you want to share things in the chat, please do so. How does your organization collect data, and in what format? And how is your organization currently utilizing the data that you do collect? The second question that I think is important is, do you share your data with other organizations? Or do you use data from other organizations or other sources to help inform what you may be doing administratively, or other things at your work in terms of the mandates that you are tasked to fulfill? And the third question that I think is important is, in what way could in some form could enhanced data collection and analysis help your organization to fulfill your goals or mandate? And I think that's really key. If you had, if the sky was your limit and you could collect data and you had the capacity to analyze it, how do you think that would actually help you do your work, fulfill your goals in a better way? These are the same types of questions that we have posed within the province amongst our justice stakeholders, and in fact have received some feedback, or quite a bit of feedback, in terms of what the answers to those questions might be. When we talk about then data and justice sector data, I think we have to look at some of the impetus for why we're even talking about, data collection and how improved data collection or analysis in the sector could actually make advances to access to justice. Probably the first, fairly discussion paper on this in Canada arose from the CBA Access to Justice, or Reaching Equal Justice report, an invitation to envision and enact, with a discussion paper on access to justice metrics. This occurred in 2013. Some of us are familiar with this, and it identified a real need for better data analysis and collection within the justice sector as a whole. There was a recognition that we don't always share the same definitions or same views of how we might define access to justice. We don't always know what we should be measuring or how to measure it. And the conclusions were that we could do better, and this was important both for the functioning of the legal and judicial systems, but also just for the proper functioning of our democratic order. At the local context, we have done a few things in lead up to the one report that I will talk about in a minute. We have a very special class at the law school called the Dean's Forum on Access to Justice. This has been running since about 2014, I believe, was the very first year that it was running. And the Dean's Forum on Access to Justice organizes leaders within the legal profession to come to the law school for a day forum. And the students, there are students that apply for and are chosen for the class. It's usually around 6 students that are chosen. The members of our justice sector kind of pick the topics of research that they are interested in hearing about, and the students they do interviews, they do research, they create papers, and then do a full day workshop with members to explore these topics of interest. In 2018, one of the groups worked on a question about justice metrics because that was of interest to our leaders in the legal profession here in Saskatchewan. And so they started that move, at least the discussion around what possible metrics could we be using to start collecting and measuring access to justice improvements as a whole across the sector. Following on the heels of that, there were 4 of us here at the College of Law, myself, Michaela Keat, Bree Lowenberger, and Brent Cotter, who at the time was the dean. Brent has gone on to become a senator and I think has just recently retired. But we did a small access to justice or a justice data inventory report. We really had no funding, but we were able to gather some information from some agencies within the justice sector to find out if they were actually collecting data and what some of the impediments were. And I still remember part of the impetus for this report was a judge from the Court of Appeal who had been at the Dean's Forum and had been a previous Deputy Minister of Justice. He, when we were asking about justice data, I remember him picking up a piece of paper and saying, Heather, the only data we have could fit on this piece of paper. And so our justice data inventory survey was really trying to test that idea is, are we actually collecting or are we not actually even collecting data? And we found that we were, but it's very sporadic and it wasn't organized. And that led to a bigger commitment that we made to try and find some actual funding and do a legal data scan report looking at legal data that might be publicly available and that's being produced within Saskatchewan. So that led to our legal data scan and the implications for a Justice Data Commons report, which you see. The funding we received for this from the Law Foundation of Saskatchewan helped fund this report, as well as I mentioned an access to justice, a legal needs assessment that we conducted for Saskatchewan. Our idea was to collect data in kind of 3 ways. What were the legal needs of people in Saskatchewan? And so we did a legal needs assessment of asking the lawyers where they saw high areas of need. We asked community agencies that are working with populations, and we looked geographically across the province and had a very good, I'll say, return on our survey from, I'll say, near to legal agencies or agencies that are providing services to the public. We timed this to coincide with a one-time legal problems survey that Stats Canada was doing, so that Stats Canada was collecting information from the public about their legal problems. And we actually paid, I guess, extra to Stats Canada so that we could ensure that we have over sampling within the province to ensure that we had good representation amongst various demographic groups in the province, and paid extra to have that a Saskatchewan specific analysis done for us. So that was intended. Since we were collecting data in these 3 areas, we also thought it made sense to look at what data already exists, and that's what led to the legal data scan report. I won't talk too much about this, but we do recognize that improving access to justice is also an international priority. We see that coming forward in the UN 2030 Sustainable Development Goals, which is promoting rule of law at national and international levels to ensure equal justice. We also see initiatives happening at the OECD. And I don't know if in the future you'll have some speakers that are going to talk about this. But the OECD has done has a whole series of work that they have done with respect to legal needs assessment. They're promoting a justice data observatory to try and support evidence-informed decision making and shared research agendas across the world when it comes to access to justice initiatives and justice initiatives across the globe. One of the more recent working papers that they have authored talks about effective governance of justice data. So this working paper was released in 2024 and is quite an interesting read for anyone that's looking at moving into the world of digital transformation in the justice sector, which I believe is exactly what's happening within New Brunswick. And so this is talking about how do you effectively govern justice data. And it looks at the role of this data governance in advancing the ability to protect security, protect information and the rights of organizations and specifically of individuals, but also ensure that we can harness that data effectively. So I've put a link in here for anyone that might be interested in this working paper. So getting back to Saskatchewan, so I wanted to talk a little bit about our legal data scan report and what we actually did. And as I said, I know this was quite a meaty report. So if some of you had the opportunity to scan it before today's talk, that's fantastic. But I believe the link is available. The link is available, and anyone that's interested in it, and I can always just email me, and I can always send you a copy as well, or a copy, or send you the link. What we actually did was we wanted to see what kind of publicly available data was existing within the justice sector, and also gauge from individuals working within the justice sector what kind of their data needs were, and whether there was an appetite to move forward with enhanced data collection or sharing practices. So the first thing that happened was an environmental scan. We did an environmental scan of annual reports from 2020 to 2021 that were published by 24 provincial agencies that were offering civil and family law justice services. So from that annual report, some of you won't be interested in this, but for legal researchers out there, I think you will be. We did a content analysis identifying the most common types of data that appear to be collected by organizations and publicly available in the annual reports. We then used what we call an access to justice measurement framework, or a triple aim approach, to identify the scope of some of the data that was available. And I'll talk a little bit about what I mean by the triple aim approach, or this access to justice measurement framework, because if we're talking about metrics or collecting and then trying to identify kind of both definitions of access to justice, but how we could measure improvements overall, this is one tool that we have been using on some other projects for doing analysis of both individual programs, but we think I've got a couple other co-authored papers that are talking about this potential organizing tool. So we did both of these in terms of the analysis. Then key informant interviews were conducted with individuals and organizations from these agencies that were looked at from their annual reports. In the interviews, we talked about or asked, had discussions or had questions about the data collection and sharing practices within the organization, how data was being used, and also about perceptions for the creation of some type of data commons or a data repository that could be utilized by everyone within the justice sector. Those there were some agencies that have some experience with data portals, and so they were asked, more specifically questions about how do you, what is your stakeholder involvement? How do you what are some barriers to data sharing? What are some things that facilitate better data sharing? And so those were showing up, and those show up, and those insights show up in the report. Now, I mentioned within the data scan report that we did a content analysis, and then we also looked at what was being collected and publicized in the annual reports based on a metrics, an access to justice measurement framework. We have been using an access to justice measurement framework that actually was developed out of British Columbia several years ago. It is built upon the health information or how many health reporting agencies are looking at improvements to, I guess, health outcomes. And so the triple aim is really looking at kind of 3 areas where we could say, if we're improving access to justice, where are we making improvements? Are we improving population access to justice? So are we improving the ability of individuals or demographic groups to actually have justice services? What are the outcomes that they are actually obtaining as a result of access to various services or processes? The other aspect, so if we're looking at improving population access to justice, another measure is looking at the user experience once they are within a process or they're within the system. So what is the quality of that experience, and how appropriate are the justice processes that we have for the individuals that are needing those services or using those services? And the last is also improving costs. Now, I put costs at the bottom, and it's at the bottom not because costs aren't important, because we all know improving costs is very important, both on a user basis, but also on an organization, of the justice system as a whole. And so cost improvement is important. But some of the time, I think, when we talk about improvements to access to justice, we spend a lot of time saying we just need more funding for legal aid. We just need lawyers not to charge so much. Those might be true, but we need to look at costs overall as one part of the picture. And there are certain things we can do to improve costs, but if we can improve user experience within structures that we currently have, or if we can improve who is actually accessing our justice services, some of these things come hand in hand, but some of them can be worked upon, outside of just looking at costs. So we find that we have found this measurement framework. It's not perfect, and we've debated this a bit at length. It's not perfect, but we thought it was a good starting point. It is being used in BC. It's being used. We've been using it for different projects where we're doing program evaluation, and we think it's a good tool kind of for orienting even the discussion about what we're meaning by giving some definition to what we mean by improvements to access to justice. Getting back to the report itself, I think we found within our legal data scan that organizations were collecting some similar data. And you'll see a lot of it was I'll say a bit operational and administrative, which was fine. Volumes of client contacts, volumes of files opened and concluded, types of services that were being provided, or at least types of files that were open for the types of services that could be provided. And one of the questions we've asked ourselves is, could this data, what's already being collected, be a starting point for building a data commons that could be used for the operations of justice sector organizations in Saskatchewan? What else did we find? We did find that organizations that do publish similar types of data, some were reporting on or providing information about length of time it takes to deal with legal matters, some client demographic information, some were doing asking about the quality, so the user experience of the services that were being provided. Some were trying to gather information at more of this population level, and some had financial related data as part of what they were collecting. And we looked at how that data fell within our AAA and found that there were some, but not many aspects were reflected in the types of data that were being publicly available and that we discerned through some of the interview data. Not all of that, and not surprising if people aren't using a certain measurement framework. We were just interested if that actually, if people were actually doing that already without having that framework with them. But we did find that most aspects of the framework weren't being reflected in the agency's data. When we looked at some of the data collected, we found that most organizations, not surprisingly, are collecting data to inform their own service delivery, but most don't have any data sharing policies. There was some concern that there has to be trust between the agencies in order to share data. And I think what we're talking about in terms of trust is that, would their data be understood, or would it be used, or would inferences or conclusions being drawn that maybe wouldn't be appropriate because they don't understand the context within which the data was collected or the context within that agency is working. So, and also trust between agencies itself. I'll mention that in a minute, but one of the issues that we face in the justice sector is we do have very different roles and responsibilities when it comes to the independence of the judiciary and the courts. That is so important to the rule of law, and so ensuring that independence is important, and independence from interference, say from the legislative or executive branches of government. So while the Ministry of Justice might be very good at doing some data analysis and can provide those types of opportunities or those types of services to those within the ministry, they might not necessarily be the ideal people or organization to help with data analysis with the courts, or even with some not-for-profits or other agencies that are dependent on ministry funding. And there is some real fear that, well, if we hand over data or we share it, will that be used in a way to cut our budgets in the future? And so, we have to recognize that trust, I'll say, and fear is real, and so that has to be taken into account when we're talking about data sharing. We also recognize that if there is a potential for a data commons, many of us have limited resources, financial resources and people resources, in terms of people with capacity to actually, give good ideas about, well, what should the metrics be? What should some of our collection practices be? So limited resources and capacity. We did have agencies that were interested in supporting a Justice Data Commons, but we heard loud and clear that the level of interest was very dependent on the purpose of that Justice Data Commons and the benefit that they could see as an agency, as an individual organization, knowing that if it took financial and people capacity to participate in that Justice Data Commons, that they needed to have, a real benefit for them to participate. So in thinking about the findings from the report, we looked at this and have done some reflection in terms of, okay, if we were going to move towards a Justice Data Commons, what is the purpose We know we need a clear purpose. What would be the intended audience then for such Justice Data Commons? Would it be for justice stakeholders to just better understand their own organization and programs? So could a justice data program commons be focused on justice insiders or justice stakeholders so that they can better, understand their program and maybe better understand their program in relation to other organizations or supports? Break down some silos, understand what role or what lane certain stakeholders or organizations are occupying, and then understand then what lane other service providers or organizations are also in. Could we use the Justice Data Commons to better understand the justice system as a whole? And if we're looking at that, then trying to come up with some metrics that can help with understanding and look to see if we're making improvements or not would be beneficial. And I say or because it could be an and, but I'll say, or is it to publicly promote greater transparency and accountability in the justice system? I do think that's a bit different because then we're not talking just about justice insiders. I use that, maybe loosely but we're not just talking about existing justice organizations. I think if you're doing something that's very public facing, which a lot of I'll say data initiatives that have been about open transparency in our, not just in our justice sector, but in various sectors, transparency for open government. We can see data commons being that outward facing for the public. And if that's the case, then maybe we would design it and be asking for the collection of information from organizations in a very different way. So I think the purpose is critical. So building on these recommendations, we looked at, a couple of pathways towards a Justice Data Commons. Do we want to, and we'll see, and I'll tell you where we ended up. I am going to, you're going to okay, I'll go back and just say, we looked at, do we want to actually build a repository? Or do we want to increase data analysis capacity within the sector? Do we want to have better data sharing infrastructure? And by infrastructure, I mean templates, agreements that take into account, concerns that we might have around trust or data sharing and security. Or do we want to start collecting data with using common collection points and adopt a common metrics? I am going to, these slides are Greenie can make these very available to anyone. So I'm going to move forward because I want to have some time for discussion around this. I'll say our Access to Justice Network met in June of last year, and we had a workshop just looking at this question. And ultimately, there was support for increasing data analysis capacity, data sharing, common collection, and common matrix, but not yet to move towards the creation of a data repository. Not surprising, because we felt we needed some business building blocks. Now, how are we organized? Dr. Panezzi indicated that there might be some questions about how in Saskatchewan have we organized ourselves to kind of move forward with this. We have something called the Access to Justice Network in Saskatchewan. It has been around since 2013 in response to the National Action Committee on Access to Justice report. It is co-chaired by our Dean at the College of Law and the Provincial Deputy Minister of Justice. That might seem a little odd, but in the initial meetings of leaders of the justice sector, it was clear that the colleges of law are often neutral places, places that most organizations would have a relationship with, and it wouldn't necessarily always be the ministry that would be driving things, especially if you were looking at organizations that may work with the ministry, but may not, but might be independent of the ministry. We have an Access to Justice coordinator for the province, Bree Lowenberger. She's also the director of Create Justice. And I just want to say, in all of the work that we've done, Bree and I have been, kind of partners in crime. She's been a fantastic, you know, collaborator on everything and leader, and I just can't say enough good things about her. Our network meets 4 times a year. 2 of those persons are full day meetings in person, and 2 are shorter, online meetings. We have standing members that of all of the levels of court are represented either by the Chief Justices or by a designate by the Chief Justice designates a member of the court. We have representatives, the Executive Director of the Law Society and others within that portfolio are standing members. We have Ministry of Justice officials that are part of this. We have representatives, CBA, Law Foundation, Legal Aid, our ADR Saskatchewan, Administrative Tribunals, Law Reform Commission, Public Legal Education, and the pro bono sector as well. So it's quite a robust group. We do strategic planning. We engage in strategic planning, and that will be coming up again this at the June meeting. But we're very much focused on being a network. We are not a committee, and the network drives the agendas. A lot of what we do is information sharing and initiative sharing. We don't take political views. We are not a lobby group. That's not what we're about. We're about breaking down silos, bringing people together so that people understand the different initiatives that are happening in different organizations. And this provides opportunity to identify needs within the sector, but also to identify projects or research or collaborations that members of the network may want. And I'm going to say, I think it's been incredibly successful. At our June meeting last year, we scoped out a plan with network members on what we should do next in terms of implementing or moving forward with some of the recommendations that came from our legal data scan. We have a very strong working relationship with the research implementation branch of the Saskatchewan Ministry of Justice. They do a lot of excellent work when it comes to data collection, data analysis, and have had a strong working relationship with the University of Saskatchewan. The Forensic Center, which was invaluable in helping us actually undertake this research during COVID when some of us were supposed to be on sabbatical and then we couldn't because we had to stay on doing administrative roles. The Research Implementation Branch and our Forensic Center here at the college and with Create Justice, it has a very strong ongoing relationship and has for years. We had network members committing to taking leadership roles to achieve some of the objectives that we wanted to achieve through a joint project. Our own dean made a financial commitment of a postdoctoral fellow in data science, and so I'll be putting out a search pretty soon for that type of expertise. And we set out a 3-year plan focusing on data analysis, sharing, collection, and matrix. And I'll just show you our last slide in terms of how we've organized ourselves. We're going to organize, or we have a commitment to organize ourselves into working groups where we have project leads, I guess, for each of the working groups, and then different organizations that want to be part of those working groups. We have an overall steering committee, again, made up of members of the working group to help oversee, and we'll have reporting back to the Access to Justice Network as well as part of the role of that steering committee. You'll see in the middle, I've put the Child Protection Integrated Pilot Project. What we actually decided upon was that we needed a pilot project that could actually pilot some of the collection. If we're saying we need to change some of our collection or improve some of the collection, what should we be collecting and measuring? We wanted a pilot that could do that. How could we do data sharing? Well, could we create some templates or we have some existing data sharing agreements that exist between the University of Saskatchewan and the Ministry of Justice. The ministry has also recently entered into some data sharing agreements with the courts. And so we have precedents that are out there, but we have to, we want to pilot them, in other contexts, and then pilot greater data analysis for what we are collecting or what might already exist in the sector. We already have at the College of Law a memorandum of understanding with the Federation of Sovereign Indigenous Nations in the area of child protection, and we have a child protection, what we call a practicum. So students that have taken the child protection course are working under the supervision of lawyers within the FSIN around Bill C-92 type work. And so we thought this was a good, given the strong relationship we already have in other areas, we thought this would be a wonderful way to pilot some of the work we do from these groups. So I have talked a lot. I guess coming back to some of the introductory questions, when I'm thinking about enhanced data collection and analytical capacity, I see the benefits from it that what I think we can achieve here in Saskatchewan. Thinking back in your own organizations now, are there things that you think could better fulfill your mandate if you could build capacity, even in a small way within your organization or as a collective within the sector in New Brunswick? How would you prioritize the following components? Maybe it's slightly different in New Brunswick than what we've done in Saskatchewan. As I said, creating a central repository was a little bit lower on the list at this time, and we thought we needed to do the building blocks of infrastructure in terms of analysis capacity, start developing common metrics and some templates for data sharing. So your priorities might be different in New Brunswick or even within your organization, but I think these are good questions to ask yourself as you're embarking on what I understand could be a bit of some transformative opportunity that you have before you when it comes to some of the work you're going to be doing within your justice sector. So I'm going to just close it at that. I think we have some time for questions. And with that, I'm going to stop sharing my screen.
Fantastic.
And turn it over to Dr. Nazi.
Thank you. Thank you so much for this enlightening talk and the comprehensive presentation of the way in which you went about certain initiatives, the way in which you're taking one step at a time, also checking with consulting with stakeholders, making sure that a network that is built and works very successfully for some years now continues to work towards goals that are identified in a common manner. So that's great news, and that's really inspiring for us. I would like to open the floor to anyone who has questions or answers to the question that Professor Heaven posed as to data collection in your organizations. A lot of our some of our attendees are also students, so they would not necessarily be able to speak on behalf of their organizations, but we do have attendees that can speak to that. And I also want to open the floor for clarification questions. I certainly have some questions that I want to ask at the very end after everyone gets the opportunity to speak. So please unmute yourself, put your hand up so that we can give I can give the floor in order. Great.
I'll start. Did you get any resistance from any of the courts?
There is resistance from the courts in the sense that, and I tried to kind of mention this when it comes to data sharing. This is why I think it's really important that it's not the ministry that's taking the lead on things necessarily. The independence of the judiciary is so important, and I think, of course, I am not, privy to discussions, but I do recognize that there is this tension between court services sometimes in terms of what the provincial, government is providing in terms of services and what the court needs in terms of ensuring that they can remain independent and do their work. So I think there is some, there's always that possibility. I do know that probably different courts are a little more receptive. There are some small initiatives, not small, I think they're actually significant. The ministry has been working with the provincial court, and I know the Chief Justice of the provincial court, I think, has been quite pleased with the types of data analysis and coming up with kind of a dashboard type opportunity. And so I think that is actually paving the way to basically prove it, right? Prove that we can actually do something and this is going to be beneficial. And so I think that's been a really great step. And they've recently, my understanding, again, working with Kim Odette at the Research Implementation Branch, is that they have signed some similar data sharing agreements with other courts. One of the things too, the Court of King's Bench here has a new process for family law matters. And as I said, our Access to Justice Network here is primarily focused on civil and family law because there's a lot of work that needs to be done in those areas. They've piloted a new judicial case conferencing, in addition to some of the family law initiatives that we have around mandatory dispute resolution or mandatory early dispute resolution. And they got some small pilot funding to do this initiative, and are now doing an evaluation, again working with data collection and getting some experience with it. And I think they're finding that this is actually really beneficial. So there is some resistance, and that's fine, but it's sometimes the proof is in the pudding. So if you can actually engage in something and find it's actually worthwhile, that's it actually gives meaning and it's purposeful. I think that's
I think
important.
It's disappointing to know that there's some resistance. I mean, I think that courts should be open to it. We allowed a couple of years ago the provincial government to not only gather but actually publish publicly data on court delays and so on. In both the trial levels, that's the provincial court and the Court of King's Bench, as it's now called, and that has actually led to good results for the courts. There have been appointments of new judges, and perhaps even the creation of a new one or two new judicial positions.
Fantastic.
And also, hopefully, it was probably part of why the recent government recognize that we need to move towards digitization because there's so much more we can do with that. I mean, we at the Court of Appeal, we keep the data that's required or that the Canadian Judicial Council asks us to keep, and we share it among all of the chiefs, all the appellate chiefs in the country. It's not the best. We currently at the Canadian Judicial Council have hired consultants to help us develop a better database so that we can actually be comparing apples to apples as opposed to apples to oranges, because the terminology that's used is interpreted differently in different courts. So me, I haven't found that data to be useful to me, but some of my colleagues on other appellate courts say that it's been useful to them. So that's a good thing. I was just recently reading the Advocates Journal, from the Advocates Society, and two of the articles in there, bemoan the fact that there's long delays and everything, and people want to change the civil justice system, but both of them say, well, we need the data first. We need to, we need data so that we can, we can't fix something without having the data first. And I agree with that. I don't disagree at all. So I think you'll find us receptive in New Brunswick to I think anyway, hopefully I'll do my best. So, Aguirre. You got my commitment. So
oh, fantastic. I don't want to overstate it. I think there are, it's all about purpose. If we can actually see benefit to collecting data, to be engaged, that's actually why we wanted to look at it from from child protection. We know that child protection, at least in Saskatchewan, is one of the busiest courts. It actually has more in its docket than the family law files. And we talk a lot about civil and family, but we don't always talk about child protection. It's kind of that forgotten area. And so given C92, that exists, and given that in Saskatchewan we have a high number of Indigenous children in care, higher numbers of Indigenous children in care than wherever in the residential schools, which is quite astounding to me. The thought was this would be a great opportunity for us to try and collect data, from the courts as well as from other areas. And so, as an integrated pilot, we thought there was a lot of opportunities here. And so legal aid is really interested in that. And we've got a really great executive director of legal aid that is really gung-ho. My goodness, every time I talk to her, it's always yes, and Heather, never but. So she's always, she's a great person to keep on.
Well, I'll end with this because there's others who will want, but just that we've recently changed our model on child protection because we do have a lot of child protection matters. That and sexual assault seem to consume most of what we do here in the Court of Appeal on any given month. But we went to the Manitoba model and implemented it here early January. So remains to be seen how well that works, but I was certainly impressed by what they did in Manitoba. So I'll end with that, but I'll thank you very much. I'll just keep quiet. I'm going to listen to the other people's questions, but thank you very much for this. I really enjoyed listening to your presentation, and I downloaded the documents, so I'll have a look at them. Thank you.
Thank you.
Thank you, Chief Justice. And indeed, in the chat, everyone can find links to the documents, the Saskatchewan report that Professor Hebben mentioned, and also the OECD report, the 2024 one that was cited. Donna Curtis Mellett wanted to speak.
It was just a shameless plug for the New Brunswick Institute for Research Data and Research Data and Sharing. Training.
And training.
That's what we do. We have the authority to hold this data. That's what we can do. So that mechanism is in place. We've been working with all the different government departments. We've been working with Justice for several years now, and we can hold personal health information. So we've got one part of the equation addressed. So it's getting the buy-in would be the big thing. So I just want to make sure folks knew that there's a resource there, and we can act as a custodian, as an information manager, as an agent. We have different roles that we can play depending on how we're holding the data for the different original data business owners. So.
Do you work out of province? No, I'm kidding.
Indeed, the work that the New Brunswick Institute for Research and Data Training has been doing is really the framework that we would need if we were if the buy-in was there. If we were to go for a Justice Commons or a Justice Depository in New Brunswick, that would be the best framework to follow, and to also ultimately be able to link justice data with other types of data, which could yield more insights, could give us more insights and lead to better policy discussions and ultimately better policy choices, which is very, very important. Which brings me to a very quick question, if I don't abuse my role as a moderator, into this difference between making data available for a network or for specific stakeholders internally, even within the courts or the justice system, which would be these different groups or these different agencies that would have access to data. Let's think about tiered access and making data available at large, because I think there's this constant fear when we hear about justice data commons, that sensitive data about sensitive groups, vulnerable groups, will be all of a sudden, without any discussion, available. on the internet, going to this extreme. And how did you navigate this? Did you find that you needed to have this discussion within the network that you, or was that already given that of course there's going to be tiered access to data? How was that? What role did access play to your project?
Okay, so thinking back to kind of what the purpose of the data commons would be, I think you've identified what some of the stumbling blocks are, or what some of the concerns are, and I know I flipped through some of the slides. Maybe if you go back and kind of look at some of the concerns that people have around a repository, you've identified some of them. I think part of it is what would be public facing and what wouldn't be. And I think that the type of data that you might be putting forward into a repository, or at least what the public could interface with, might be different than maybe what might be available to others. And so I think you'd have to think about that. For example, again, I flipped through this. I think there's a really good, it's out of BC. The court services branch of BC has a nice, very public dashboard for courts and the court. And so it's very public facing, and it gives information similar to what the Chief Justice was talking about what are the wait times, what is the how long does it take for this? What are the types of files? So there's public-facing information that could be available that is still important, but it wouldn't necessarily mean that you were giving access to sensitive data, or you wouldn't be publishing that. But I think that also then goes into what are you collecting? And we all know when it comes to privacy and access, what are you collecting and for what purpose, and for what limited purpose, that you're collecting it for. And if you're going to collect it, you have to use it, right? You're going to have to use it. And that's a bit of a stumbling block, because we know that we might want to be able to use it, but if we don't have the analysis capacity to do it, then maybe we can't collect it in the first place. And if we have to collect it in a few different formats, or there's restrictions on what can be, you have to be able to build your repository in a way that ensures the integrity. So certain things aren't being made, available that shouldn't be, even though it would be really good to know certain, say, demographic information, or know certain types of information. So, have I figured this out? No. That's why we have working groups. And the idea is, let's start with, good data sharing agreements and understanding, between organizations or among organizations, how might we share it? And we think those are going to be the infrastructure, I'll say the legal building block agreement infrastructure that could lead to decisions about, okay, this seems to be, how these are concerns. So how would we build then a repository, or how would we build from that, from the infrastructure that we could create, just, through agreements, with other groups. I don't know if I've answered your questions, because we're still in, early stages, but these are all, we are thinking about them, and that's probably the biggest reason why we haven't said we need a repository right off the bat, because we haven't worked that out. On another hand, I have been having let's see, but quarterly meetings with a group in the health sector, both nonprofits and within the Saskatchewan Health Authority. They they want a data commons as well, and as you said, integrated with different types of data sets. It'd be great to have health, social services, and justice data, because you could answer different types of questions, or maybe target services in a very different way, or understand problems. And I agree. They are very much want open data and want it organized through a not-for-profit and not have government involved at all. And and there is a bit of a model for that in Manitoba. Again, if you go back in some of my slides, I think I've made reference to some different opportunities or different things that are out there as models. We're not there yet, even close, but I just know there's so much built up need and interest, and I just feel, personally, I just feel like I can't move fast enough on some of this. But I guess and it takes a village, and there's a lot of really great committed people that are in Saskatchewan, and so I'm optimistic that we'll move forward.
Thank you. Thank you so much. Thanks, Heather, for also bringing your enthusiasm and your optimism and sharing your optimism with us, because it seems like you managed to keep the energy going. It's not something that can happen overnight.
No.
That's another lesson learned from the Saskatchewan experience. A dedicated group started in 2013, if I understood well. So that it takes time, and that there's progress along the way, but it also takes time, and these are important decisions that will be very fruitful in the future, currently, but also in the future. So it's an investment.
Yeah.
From what I understand and from what we expect as well, thinking about New Brunswick. Thank you so much. This was fantastic, and I will be sharing the video with you, and with your permission also, making it available to more people that would like to access it, and your longer report, the resources that you've shared with us. Feel free to reach out, and then we'll share the resources or put you in contact with Professor Haven.
Great.
Thanks.
Thank you so much for having me.
And thanks all for bearing with us a little bit over time again today. Thank you.